Are you a current Abrenio law client and we just settled your case and you want to know what happens next? Watch this video to find out. Hey folks, James Abrenio from Abrenio Law, your Northern Virginia personal injury and criminal defense law firm. If you're watching this video, chances are you're a current client. Maybe you're a prospective client. You want to know what happens when we settle cases. But if you're a current client, I want to encourage you to watch this video all the way through because my goal is to give you kind of a framework of what you can anticipate once we've settled your case. So let's assume that we've spent time litigating your case and we're now at the point where we've agreed on a number, or perhaps we haven't filed the case and we've managed to get an offer from the insurance company and you're happy with it and we've agreed to the number and you say to me, James, go ahead and get it settled. What happens next? So what I will do once you've given me authority to settle your case, I will reach out to the insurance adjuster or the attorney and say, hey, look, we're good with that number. Let's get things moved along. So the next step that's going to happen is they're going to send me a release, a settlement release. And essentially that settlement release is a contract between you, the defendant person that caused your injury, and the insurance company that essentially says they're giving you this money. And in exchange for that, you're waiving any other further claims of damages and injury and future damages, injury, lost wages, etc. And you're accepting this amount for purposes of settlement. Usually those releases contain a lot of language that can be legalistic and use fancy attorney terms. So whenever I then get a release, I will actually take time to review it. So what are the major components of a settlement release? Again, usually it's going to state the amount. It's going to state the amount of settlement. It's going to state the defendant. It's going to state the insurance company. It's going to say, in exchange for you getting this money, you're waiving future claims against usually the defendant and many times the insurance company. When I look at those, though, I'm always careful because a lot of times these releases may also ask you to waive any and all their claims against any other thing under the sun, sons, daughters, cousins, best friends, all those kinds of things. And while usually if we're settling your claim, you're not going to have additional claims against other parties unless we've discussed it. I don't like that language in there because we didn't negotiate, frankly. So oftentimes I will then work with the insurance company to narrow that down and get out entities that were not negotiated for in the settlement. Another component the settlement release is going to contain is essentially a statement that says that you're going to be responsible for any outstanding medical bills or health insurance liens that are owed. So if we're at this point in your case where we're settling it, hopefully we already had this discussion, but medical bills not paid that I, the attorney, am aware of, I will usually pay those medical bills from your settlement funds. If those medical bills are not paid, then you, the individual, will owe those dollars. So the insurance company and the defendant want to make sure that they're not being hit with those bills. If you have a health insurance company that pays your medical bills, under Virginia law, they may or may not have a right to a reimbursement. Medicare does have a right. So there's other entities and other insurers that will have a right to reimbursement. And again, hopefully if you're watching this video, that the details of that about what is likely reimbursable and all that, that's another subject for another discussion that we've already had. But the release is going to want to make sure that you're liable for those if there turns out to be any outstanding medical bills or releases. And that's fair. Now, other insurance releases will also say something to the effect of you're required to indemnify the insurance company or the defendant if an insurer or a medical provider claims that you owe it and then sues them for that. And indemnity language, a lot of times I will try to remove because I'm always concerned about a health insurer or a provider wrongfully suing you and the insurance company and then you having to pay for that mistake. Now, sometimes insurance adjusters and attorneys will push back on that and we'll get into the nitty-gritty with your individual case about what makes sense. But I don't like indemnity clauses in releases, so I will usually try to fight those. I also look for other language that's not important or not necessary that we haven't negotiated for. For instance, some require confidentiality. If we haven't agreed to a confidentiality of the settlement, then I'm going to take that out. Now, if confidentiality is part of your settlement, then that's obviously going to be part of the release. And we'll talk about that in your case. Now, another provision that's typically going to be in there is that the defendant doesn't admit liability for paying you money. That's part of the benefit to them about settling the case, is they're not admitting the liability. Now, you may say to me, James, in order to settle this case and for them to pay me money, I also want them to admit that they were wrong. And if they're not willing to do that, then I'm not willing to settle. I could just tell you most insurance releases are going to require this. So if you think that you're going to get a settlement with admission of liability, that's going to be very unusual and you're probably going to go to trial, that's fine. But just be aware, if you're considering settling for a certain amount of money, usually there's a financial benefit to you. Perhaps we weren't going to get a lot more from a jury. Perhaps litigation costs were going to be very expensive. Perhaps liability is an issue. But there's going to be other benefits that you are going to have to be waiving if you expect to try to get an admission of liability. And again, it's okay to go to trial, but just be aware of the cost-benefit analysis. And I do want you to expect, if you're going to be settling and signing a release, that will have a document, part of the document that says that they're not admitting liability. So once we get the release taken care of, once I review it, I will get it to you to review, and then I'll get it back to the insurance company. Triggers the check, the actual settlement check, to be sent from the insurance company to me, the attorney. Now, to be clear, settlement checks are going to go to me, the attorney, and it's going to be usually made out to my law firm and you, the client. And then I will deposit this check into what we call an IOLTA trust account. Essentially, it's an account in my bank where the money sits, and I don't do anything with it until essentially we've agreed to where all the funds are going. So typically, in a personal injury case, we've agreed to settlement funds. Before settlement, I've given you a projection of costs, any referral fees, any other litigation costs. I've at least given you a good idea of what to expect when the settlement funds are going to be split up. Once I deposit the check, but before I disperse anything, I'm actually going to get you a bunch of documents. One is going to be something I call the internal settlement release. It's essentially a document between you and I, my law firm, and you, the client, that essentially lays out in detail the breakdown of the settlement funds. This much is going to me as attorney's fees. This much is going to be reimbursed for litigation costs. This is what's going to go for the health insurance and outstanding medical bills. And then here's your dollars that you're going to see in your pocket. So when I deposit the check, I will then create this document, and I'll get it to you for your approval. Once you agree to everything and you've signed off on everything, I will then create a settlement package. And I will give you a copy of the checks virtually, and then I'll have you sign off on the internal release, usually virtually, and then we'll arrange a time for you to actually come in and pick up your check. Sometimes clients want me to mail the check to them, which I can arrange to do. It really depends on the size of the check and your location. For larger checks, I'm a little bit more hesitant to do that because if it gets lost in the mail. For, quote, smaller checks, I'm a little less put off by doing that. I just worry about checks going through the mail and getting lost. Now, you are probably asking at this point, James, how long is this going to take? When am I going to see actually money in my pocket from the day I sign the release to the day I have money in my pocket? And I will say this is hard to predict. Because logistically, every case is a little bit different. Sometimes it takes a little longer for the release to get approved. Sometimes it takes a little longer for the check to come to me. Sometimes it takes a little longer for you and I to work out the details. But typically, I would say a good estimate would probably be about 3 weeks. It usually takes me about a week to get the settlement release approved by you and to the adjuster, and for them to send out the check. And it takes for me a couple weeks to get the actual check in and deposited, and then about a week for me to prepare the disbursement instructions and settlement release for you and all those documents. So I would say about 3 weeks. Sometimes it can be a little bit quicker. Sometimes it's a little bit longer. But I can tell you that at least my practice is, when it comes to money, I understand how important it is. Clients need settlement funds. Doctors need to get reimbursed. Health insurance companies want to be reimbursed. So I do my best to work through these things as quickly as I can. Sometimes being a small firm, logistically, it can be, if I have multiple settlements going on at once, it can take a little bit longer as well. But I try to do a good job of talking to you and letting you know through the process what's going on. And hopefully we've had a kind of a more specific discussion about what the circumstances are involved in your case. And I always tell people, look, you can reach out. Whenever it comes to people's money, I understand. My goal is to update you as soon as I can. So if I get a check, I'm going to let you know. If I deposit a check, I'm going to let you know, and all those kinds of things. But hopefully this provided you kind of a gray goalpost as to, what you can expect and what you should expect and what documents to look out for. But to be clear, you're going to be seeing the numbers. Don't be worried about, checks just going out without your authority and all those kinds of things. I want to make sure that that you totally approve everything. The other thing is sometimes I want you to also look at the documents that I send you. If I send you the internal release with the detailed breakdown of where the funds are going and there's a question about the math, I always tell people, I'm not trying to nickel and dime you. If there's some math error, just let me know. I'd rather have a client. I'd rather lose a little bit of dollars because I messed up on a math area rather than lose your trust. My goal is to be thinking about you, not just once the check is in your hand, but I want you thinking about me a year from now, 5 years from now, 10 years from now, in case you or somebody else needs me. Hopefully you don't, but if you do, you can always reach out. So if you have any other questions, specifically if it's about your own case, feel free to reach out. Hopefully this gave you a little bit more information as to what you can expect. And if you also have other questions, you can check out the website. Obviously, hopefully by now, if you're a client, you've realized that we put a lot of information out of there. But thanks a lot. Hope this is useful. Take care.